My name is William Moore, a founder of W.R. Moore Criminal Defense, Dorenzo and Wyke, and today we're going to talk about the basics of burglary under Florida criminal law. Burglary. It's the entering or staying on a residential property, structure, or conveyance meaning a car, with the intent of committing some criminal offense. This excludes premises that are meant for the public, and if a person is invited or licensed to enter that premises. Okay? We're strictly keeping the places confined to private structures, conveyances, homes. Public buildings can also have regulations preventing the public or offenders from entering the property. To prove the charge of burglary, the prosecution has to establish, number one, that the accused did not have a legal right or permission to be in the dwelling, residence, or structure, or conveyance. Number two, the accused entered or stayed in the house, building, or conveyance. And number three, that the intention of the accused was to commit a crime inside the premises, the vehicle, or wherever the heck he was. When it is established or proven that the person did not have permission or the legal right to be on the property or the vehicle, but the intention to commit any crime is completely absent, then charges for trespassing may apply, but not burglary. And there's a vast difference in terms of sentencing severity between those two crimes. I think trespassing is about as low as it gets. Burglary is quite serious. The levels of severity, of course, depend on whether it was a structure, a conveyance, whether or not it was occupied, things of that nature. We'll get more into that. For a burglary charge, it is important for the prosecution to prove that the accused intended to commit some crime, like theft, criminal mischief, vandalism, or the really bad one, some form of battery. Also, the accused does not have to be caught in the criminal act, committing the criminal act, such as stealing or battering, in order to be charged with burglary. Merely establishing criminal intent is enough to make an arrest. And this is something that needs to be reviewed as well. How the state will seek to, and how the state is allowed to under Florida statutes, to show intent, to prove intent, beyond and to the exclusion of any and all reasonable doubt. Now, the types of burglaries. Florida law differentiates between the forms of burglaries by considering where the crime is taking place, like I had just mentioned. The burglary of a dwelling, once again, a structure, and a conveyance. These carry different weights, they're different levels, carry different sentences. Burglary of a dwelling. That's a home, a residential premises. In these cases, the home is either going to be occupied or unoccupied at the time of the crime. Dwellings include the home, the garage, things attached to the house. A railroad car has been found to be a dwelling. Aircrafts, an inhabited space of a building, a warehouse where someone was living. So these could be occupied homes. Residences. Now, burglary of a structure. A structure is different. Burglary in non-residential premises, also known as business burglary, considering the place that the act is committed is a commercial establishment, like a shop. The severity of the crime will depend on whether the structure was occupied or unoccupied, just as in the case of a residence. Finally, we have burglary of a conveyance. That's a car. Burglary of a motor vehicle. Once again, whether or not the vehicle was occupied really comes into play. Now, what is one of the more severe burglaries of a conveyance that results in a no bond hold? Is a first-degree felony. Well, it's when a fist fight spills out into the parking lot from the bar, and someone gets in their car to drive away, and one of these macho guys wants to get one last parting shot in, and he punches the driver through the window. Well, you've entered the vehicle. The assailants entered the vehicle with their fist, and of course the intent was to commit a battery, so that's quite serious.